In 1889, Copper King W.A. Clark and 74 other men wrote a state constitution to serve the needs of Montana's powerful interests, with a weak governor, a secretive legislature, and special tax deals for the powerful. After 60 years under the copper collar, Montana was declared the nearest thing to a colony of any American state. The Anaconda Mining Company even owned most Montana newspapers, the Copper Press. The corporate dominance of Montana's political affairs was unique in American history. 70 years after statehood, the Copper Press was finally sold, and thousands of World War II veterans had been educated under the GI Bill. Newly enlightened Montanans wanted out from under the copper collar, and big winds of change roared across the Treasure State. Changing Montana's constitution was the top priority. Strengthening the governorship, opening up the legislature, empowering citizens. Voices of Montana women, totally silenced in 1889, rang out loud and clear for these changes. When the Constitutional Convention began, 19 women were among the elected delegates. And when the delegates came together in convention, Democrats, Republicans, and Independents, men and women, young and old, sat alphabetically as equals, Montanans just wanting to make their state better. And so they did, producing a constitution for the ages, the last best constitution. Now, at its 50th anniversary, Evan Barrett and real history makers of the time shine a light on the creation of this remarkable Montana Constitution.
Welcome back to Last Best Constitution, our series of broadcasts about the 1972 Montana Constitution. We are celebrating the 50th anniversary of that Constitution, which is arguably and generally accepted as the best state constitution in the nation. It was put together by 100 delegates in 1972 after the people voted 65% to call a convention to help Montana escape from the copper collar that had constrained the activities of Montana government for 83 years since the 1889 Constitution. And when those 100 delegates got together from all across the state, citizen delegates, they were not elected officials, they had to be citizens. Those citizen delegates came together. And when they came together, a lot of preparatory work had been done in anticipation of the Constitutional Convention, research done on the various elements of what makes a good constitution that would help them get a running start, if you will, on the effort. And of course they had to, because they were only allowed 60 days to do it in. One of the things that made it really work was that the preparatory commission for the Constitutional Convention had hired a staff, and the staff was doing massive amounts of research and accumulating it for the delegates. The folks that did that were called the Research Analysts, and they were an amazing group of young men and women who were Montanans who were right in the mix of trying to create a new Montana. And we are honored today to have one of those research analysts with us. So welcome aboard. This is Rick Applegate. Glad to have you here.
Good morning.
Rick and I have known each other for a lot of years. Well, all the way back to then.
Almost more than I can count.
Yeah. Well, thank God we're counting.
Yes.
In any case, Rick, you were originally from Libby.
Yes.
So tell us a little bit about your background that led up to the point of being at the Con-Con.
Sure. Well, I was born and raised in Libby, stayed there pretty much until I went away to undergraduate at the University of Montana. And I spent 3 years there, and actually a couple of summers in the mill and a couple of summers on Forest Service lookouts up around Whitefish and near Nyhart, Montana. Went from there, actually I got in my car, and 5 days later I was in downtown New York City, where I started graduate school in the fall of '70. Toward the end of my first semester, I came out to Montana and bumped into Senator Luke McEwen from Anaconda, and he wanted me to go to work with him. He was getting bogged down in executive reorganization, which you're very familiar with, during the 71 legislative session.
Luke was a member of the Executive Reorganization Commission.
Yeah, he was chairing the committee in that legislative session.
And it was he was quite involved in that very important thing. And of course, he had a great capacity for reaching out to young people.
Yeah, and he grabbed a handful of me. I ended up staying, working with him during the session, shuttling back and forth to the House. Duke Crowley, of course, and the Governor Anderson were deeply involved. Sheena Wilson, you were in and out of that.
Diana Dowling was in on it.
That's right.
George Bosleman was there.
Right.
Yeah,
it was almost like all hands on deck.
Yeah.
You know, it was a very big deal. And toward the end of the session, my goodness, I was still 21 years old. Luke had talked to me about the Constitutional Convention. I was approached by Dale Harris, who was in many ways the mastermind of the Constitutional Convention. He had been working on the preparatory work for quite some time.
In fact, we have in our in the series in the Crucible of Change, the show about Dale Harris is entitled "Godfather of the Constitution."
Yes, he was that, and a whole lot more. A real inspiration for the work before, during, and even afterwards. And I was fortunate to meet up with him, and we struck up a couple of conversations. And he was aware that I was a student of political philosophy in graduate school, and he asked me about working for the commission, and I said that would be interesting, and then he told me what he had in mind. And I was very fortunate. It was the Bill of Rights, including the environmental provisions. And I couldn't imagine anything else that I really was interested in doing. So I think I used about a half a sentence to tell him I'd be delighted to do that. And then, along with the other researchers who were picked up, we were called, I don't know what to make of it, we were called the Young Turks. and we all were quite young. And as we sat around thinking about the work we had inherited, we started to wonder two things. Best jobs we're ever going to have, probably, and what if we blow this? Yeah. It was possible to fail at it, because we actually only had, those of us who were hired early, had roughly 8 months. Yeah. And I guess I did win the award for the thickest and the heaviest document. Mine was 400 pages, and I wrote somewhere that the reader, diligent reader, was left to stagger into the bibliography at that point. And Jerry Holleran, noted Montana journalist, was our editor. He was the assistant director to Dale. And so we would take him our materials, and he kept seeing more and more from me, and it was getting later and later, and he wondered in his own special way if I was going to finish on time.
Well, you do, and I was a couple of years older, well, not much, when I started in the reorganization. Right. And you do suddenly, as a young person, you have a degree, and you kind of think you know everything, and then you're confronted with the real world, that you have this, what is really an awesome responsibility. Yeah. And it is, boy, you got to knuckle down and get it done. It's really something else.
I was studying in a cubicle in graduate school, and I had the office right behind the House Gallery. Two huge tables I was working on, a chapter on each. And then in Catherine Orchard's Law Library, I got to take over a table there. She even gave me a key and let me eat there. She looked away while I was hogging down food.
God bless Catherine Orchard.
She got the job done. We didn't have the internet.
Yeah.
Right?
That's what I was going to get into. This idea of research for people today looking at this thing, well, just Google it up.
Right.
Right? You had to do interlibrary loans and have stuff brought in from all the way across the country, and copies of things sent in by mail. And that was just the effect on the timing of research as opposed to today's dramatic difference.
The reason I had 3 different projects going is we were always waiting for material. Yeah. And we were never quite sure we could get it. Occasionally we'd get something and it would be the wrong thing, or it would be incomplete. And so you've waited 10 days, you're roaring to go. You know right where it fits, or you think you do, and it's not there.
I think the fact that you were there, as fast as those 8 months went, imagine if they started the convention and started the research at the same time.
Wouldn't have worked.
Never happened.
Never would have worked. No.
Never happened.
No. And the I think the quality of the work was assessed by people. I've heard a lot about it, not just mine, but that they really thought it was well done, that it was fair. The commission had some big names from Montana on it. I mean, Marjorie Brown was there, Ellis Waldron, Eugene Mahoney, Alexander Blute, of course, was chairing it, and others. And they looked over that work. When we met with them, they had read through it. They had questions. They had suggestions. No one tried to sort of bias the work one way or the other. They wanted us to dig up, though, everything that might be relevant in the constitutional context. And fortunately, there was a fair amount of literature in law reviews and elsewhere on civil liberties and most of the other areas, because the National Municipal League and others had been talking about state constitutions for some time. And they had published a few documents, and others were writing on it. And
a few other states had been trying it too, not all with great success, but nonetheless there was this experiment in constitutional revision going on.
In fact, we had some eye-popping failures just before the Montana Constitution back east. And there were a couple of states that were unable to ratify. And most notably, everyone figured Maryland in 1968 was a shoo-in. It failed. And the delegates were aware. I pointed out to the Bill of Rights Committee early on, it was in my study, the states that had not ratified. And their reaction was uniform. I was kind of surprised. It was, okay, that's fine, but we're going to write the best document we can, and we'll deal with ratification. The chips are going to fall where they're going to fall. It didn't scare them into anything. At some point early on, some of them would look at proposals and say, well, that can't be adopted, that can't be adopted. And some of us, when you said we were young, we were, and I don't think we thought we knew it all, but we actually were critical in public, several of us. And after we did that, we all thought, that's out of the ordinary.
Maybe not our role.
No, and so we waited for a reaction that we never really got. In fact, some delegates said, oh, okay, we understand. And they went right back to work. It was as if nothing had happened.
This cadre of folks that were doing the research up front and that you were in was quite a group. And I'm not going to name names or anything now, but the quality of that group was pretty amazing, and it played out in their futures when you saw what did these folks do when they left.
Yes.
And so before we get back to the thread of what's happening, tell me a little bit about, and the audience a little bit about, what did you do after you got done with the Constitution Convention? Because you've had quite a journey of interesting and responsible positions that have been pretty marvelous for a person.
Yeah, well, again, I've been very fortunate in my career. I was interested in public activities. I thought about academia, about teaching for a while, and I did a bit of that at Montana State University in the mid-'70s. But when I left the Constitutional Convention, I went to work for the brand new Montana Environmental Quality Council. Fletcher Newby was the executive director. He was aware of my research and other activities. And we were dealing with early versions of an energy policy and a land use policy. We were doing program reviews. I was talking to agencies one after another. They felt like the Environmental Policy Act that required the environmental impact statements really didn't need to apply to them because they were already doing things.
We don't need that. And but of course, in the era we were in at that point was the first Earth Day was in 1970. So this was the movement was just springing up. And
it was quite a new thing. So I worked there for a while. I went back to graduate school briefly. Came back out, did some more work at the Environmental Quality Council, and then I set up a kind of a public interest research and law operation in Bozeman. We dealt primarily, but not entirely, with conservation issues. And I worked there. We had a law firm on retainer. They were just getting their practice together. It was Jim Getz and Bill Madden. I did that for a number of years. And
by the way, Jim Getz spent the next 50 years cutting a pretty nice, sharp line right into the law about how to get stuff done and make sure it gets done right.
He's been rewarded for the excellent work he's done. To the attorneys, just as an aside, that I've worked with off and on, Jim Getz was one, and of course Mike Malloy, who helped. We'll get into him in a bit. But another attorney who has spent decades protecting some of the provisions in the Bill of Rights. After the Center for the Public Interest, I wanted to see what was going on really in Washington, D.C. So I went back there and fortunately landed a position with Senator John Durkin of New Hampshire, Democrat from New Hampshire, former insurance commissioner, feisty guy. And about 4 months after I was hired into his office as a legislative assistant, he called me in and wanted to know if I would take the basically staff director, administrative assistant, it's called, position. I told him I would. And I walked out of his office and got on the phone with Leon Billings, Montanan, who was Senator Muskie's aide at the time, and Steve Browning, who was Box's aide. And I said, look, I'm going to bring the beer, and you guys need to explain to me what you have to do in this job. I knew some about it, but they were very helpful to me. So I worked with him. He was not elected in the 1980 landslide where By and Culver and Gaylord Nelson were swept out of office. I went to work in Max's office and was actually was called the Minority Staff Director of the Separation of Powers Subcommittee of the Senate Committee on the Judiciary. And I only say all that because Joe Biden was the ranking minority member. And I got to see him up close back in the old days. After that, I was in Max's office. I was senior LA in his AA for a time. And then I went over to the House
Interestingly, by the way, for a lot of people don't know this, and we'll cover it in a later episode, but that Max was a staff member of the Constitutional Convention. He not a research analyst, but he was a staff member.
No, he was making sure the trains ran on time. We actually had our heads down so much, I didn't see very much of Max, nor did many of the others, but he was kind of getting things lined up so the committees were ready when they needed to be ready, and that's part of the reason they got done in the amount of time they did. Well, over on the House side, I worked there, and then I got a phone call from Portland, a friend I knew who was the executive director at the Northwest Power Council. And they were having some difficulties with their energy standards and their fish and wildlife program.
Which was kind of a new thing that had been created to allow the states to have some kind of a role in what was the Bonneville, or that region of the public power.
It was to guide and in some ways constrain Bonneville, and it was a 4-state compact approved by Congress after years of work by Senator Jackson and others. And I worked there for 10 years. I was the director of the Fish and Wildlife Program, eventually covering the entire Columbia River Basin from Montana to the ocean, got involved in the U.S.-Canada Salmon Treaty negotiations. Spent a couple years covering the West Coast after that for Trout Unlimited, which was quite a position. We got to see some wonderful streams in the course of that. And then I got a call from National Marine Fisheries Service and joined them, and eventually was in charge of their Habitat Conservation Division. Just at the time the listing of salmon doubled the area that was protected for salmon and steelhead restoration. And then I didn't end up back in Libby, but in a way I did. I was hired as the administrator of the Portland Harbor for the city, of the Portland Harbor Superfund site. And being born in Libby, it turns out I've had a lot of experience with Superfund without knowing it, because my family, a bunch of people I knew, were exposed to the asbestos there. And we still get checked periodically for that.
You are currently an avid bird watcher operating out of Tucson, is that correct?
Yes, and we traveled for quite a few years. My wife's photography skills have ratcheted up. I don't shoot stills anymore, there's no point. I do shoot a little bit of video, and most of that gets edited into oblivion.
Well, your reputation is sterling, and your history is pretty admirable, and it speaks to the quality of the people that you similarly that you were working with. That made, quite a group. I mean, really, I every time I look at that list, I think Dale Harris could pick talent.
Yeah, their resumes blossomed, and we all admit we were very, very fortunate. I mean, I just feel very fortunate that I have been able to work on the issues I've worked on for as many years as I have.
I've often looked at some of the positions I was in, and especially those seminal positions at the beginning of my career, where suddenly you're in a place and you're just chugging along and doing the work, and when you walk away from it, you realize, man, I was right there, and boy, did that set me up.
Yes.
Well, you know, it really opened doors for me and things like that.
It did, but even less than the career opportunities, the kind of work that you get to do when you're closer to the center of what is actually the action. In some cases, it's the illusion of activity in Congress, you know, but it's amazing the number of issues. If you're in a good position, the number of issues you get to deal with, but you have to handle well, because there's nothing like taking on an issue and making a mess of it. And fortunately, we did not have that problem, as far as I'm concerned, during the Constitutional Convention at all.
Pretty astounding. Now, when you were assigned the Bill of Rights, which is referred to as the Declaration of Rights, and so you researched bills of rights. We're all familiar with the original U.S. Constitution, first 10 amendments, Bill of Rights, and there have been 17 or 18 more amendments since then. But that's the core of protections that were put up that protected citizens and states supposedly from an overbearing U.S. government. It has a lot of interesting meanings in it. But out of that emerged that the state constitutions began to repeat that. But tell us about when you first got started. You were doing the research on this. When those delegates came in, I bet you were interested in who's going to be in charge of this.
Yes, yes. Well, and just a quick thing on the history. Actually, state constitutions were first.
They did proceed.
Yeah,
that's correct.
And Massachusetts most notably, but some others. And Professor Johnstone at the University of Montana has put out a casebook, that a brand new one, just out in the past month, and I've been recommending it to
You know, I was going to
fans.
buy that thing, and I saw it. It was the price of a textbook.
Well, it is, and it is a textbook.
And by the way, it made me have great sympathy for students who have to buy books, because it was pretty darn expensive. But nonetheless, Anthony is a really a great scholar, and he'll be part of our series as well.
It's an incredible piece of work, and I haven't had a chance to talk to him yet, but I'm well into the middle of it. And it's very informative, and then it has a series of questions and all that. We probably could have used that back then, but it probably took this amount of time for him to develop the theories he has about state constitutionalism and to write it. It's a good read, particularly if you're anywhere near legal work or public policy work at a high level. It's very valuable from what I've seen of it so far. So,
So the election was held in early November of
and
1971.
here come the delegates,
And all of a sudden, the delegates come in.
Yes.
Did you? And the first thing they did was have an organizing session. And there's a few things about that I'm going to ask you about. But as they were moving toward that, it was late November 29th that they gathered in Helena to select their leadership. And as a staffer at that point, staffer of the commission, were you anticipating, looking forward to seeing them come in? How did you observe that process as it was going on?
It was still it was time for them to arrive. Obviously, we knew that going in. We were still doing some preparatory work, and as they did come in, I would meet with individual delegates. Would drop by, even some before they knew which committees they had, just to get acquainted. And they had our documents already, and so the Rachel Mansfield, the rear seat of her car was apparently stacked with material throughout the convention. So it was kind of an informal time to get to know them. We didn't get so much involved in the formal organizational work. We heard rumblings about it from time to time, because I think the delegates themselves were finding their footing. There were Democrats and there were Republicans and some independents who were elected. And it took a little while before they arrived at what I think turned out to be a magic proposition, that they set all that aside as best they could. And it wasn't just symbolic. They seated themselves alphabetically and developed the kinds of relationships that I used to see in the U.S. Senate. But this was even before that, and they started working together without ideological distinctness, without the aggressive exchanges. I mean, they had their debates, of course, but it was a nonpartisan kind of an approach.
And when you say which used to be in the U.S. Senate, it's worth noting for our viewers that was the much more collegial U.S. Senate. The biggest, the best club in the world, they would say, and they all at that time worked together, which is not something we see today. So for the folks that are viewing, they need to know that the Senate you're speaking of was different, but when they sat alphabetically here in Montana, it made a big difference according to everyone.
It did.
And
I consider it a model. When I did work in the Senate a little later, we worked, Democrats and Republicans, every day. Every day. Mm-hmm. There were debates, there were differences of opinion, there were votes that were very close, and there were contentious issues. But by and large, there was an honest effort beyond the personal level, mm-hmm. which was also there, in public life to work together. And it wasn't that people were just compromising because it was easy. They were collaborating because it was hard, and the issues were hard. And they're harder now, and you're right, it's night and day from what I saw in the U.S. Senate and what I observe now.
And in Montana, we had a situation where the folks were not elected officials.
Right.
And so, the alphabetical seating, it produced a kind of a collegial thing here that was actually genuine. Yep. And all the delegates to this day speak that that was a powerful force and influence for them to be able to work together.
To this day, I have to look back occasionally to see who was a D and who was an R, honestly.
And there were 58 Democrats out of 100. There were 36 Republicans and 6 independents. Right. But there was a power sharing. Mm-hmm. Alternate committees were headed by a chairman of one party and usually a vice chairman or chairperson of the other party. Mm-hmm. And there was a willing sharing of power that we've spoken to in some of our previous episodes.
Yes.
When did you get wind of who was going to be on, when did you first find out that you were going to transfer over and be a staffer for the convention, and then who was going to be on the committee? Tell me about that.
It wasn't entirely clear when that actually solidified, really. But the day I knew what was going to happen was the day an imposing gentleman walked into my office, and it was Wade DeHood. And
Delegate Wade DeHood from Anaconda.
You could feel the oxygen in the room change. Very forceful personality, as you know very well, personable, and he said, "I will be chairing the Bill of Rights Committee," and he had looked at the material and he appreciated it. And he said, and there are a few things, right away, he said, there are a few things I'm very interested in here that you need to know about. And we were off and running. And he was Republican, trial lawyer, spent the bulk of his career working on some very difficult issues for some clients who in one way or another were afflicted or disadvantaged, down and out. And he built a very successful practice at that. And he felt very keenly the importance of individual rights. Mm-hmm. It just rained off of him whenever you talked to him, and when, as I've described, he would grip your arm when you were standing with him and hold on to it as he explained his position.
And never let go till you understood exactly what he meant.
You had to understand for sure, and it would help if you actually agreed with him. And it wasn't like an assault or anything. It was Wade DeHood, and
firm belief.
I miss him deeply. He unfortunately didn't make it to this anniversary celebration.
Just a few months early, he passed away.
In April. Yeah. He and Bob Campbell, another committee member. But that's what happened. I met him and then gradually met the other delegates. And then fairly quickly, again, we weren't in much of the organizational work. We were in detailed, lengthy briefings. Mm-hmm. And the delegates weren't nodding off. We went through the material, and all kinds of questions were asked, and there was more work to do, obviously, as a result of that. It's not like I turned in a study, got a grade, and got to go for recess. It was running a dead run all the way through it.
Now, let's talk about what the substance of the Declaration of Rights, because Montana, it is said, and I believe it, Montanans have more protections than any citizens in the United States as a result of that Declaration of Rights. First, let's talk about the concept of keep all the previous rights and build from there.
This was one of the first things that Wade raised, and he was very thorough in his discussion of it, and he raised it several more times. He wanted to be absolutely sure that whatever we did not diminish or lose track of any of the rights in the existing Bill of Rights. And I think we adhered to that. We were very careful about it. We would go back through the '89 Constitution, and we would even take a look at some of the other constitutions, federal obviously, but also some of the state constitutions of in the history, to see if there was anything we were missing that was referred to or implied in the '89 Constitution. We wanted to capture it if we could. We didn't stumble onto much. The other thing I would say in general, though, is going into this, no one really, including me, I wrote as broad a study as I could. No one expected that we would end up with the provisions we ended up with. We knew there would be more, but I described, I guess, where we ended up as it's what's known, the product. What happened is what's known in the national pastime as long ball. Mm-hmm. Cleared the fence, mm-hmm. I think. Mm-hmm. And that's how people have looked at it. I've not seen anyone criticize it that it was somehow truncated or incomplete. There are still debates about some of the provisions, but no one really questioned the adequacy, the completeness, or the glory of that document, frankly.
It's no question about it that the breadth of the whole thing stands out. It stands out, and I often almost always remind folks how much protection they have. Yes. And we'll talk about some of those key elements. There's some of those that were cutting edge, and by the way, these are always subject to interpretation as they go forward. But there's a breadth of protections that are pretty amazing, and some of them are. Let me start with one that most Montanans have experienced in one way or another, and it's a unique provision in Montana's Constitution. I believe we're the only constitution in the nation that has a constitutional right for people to participate in the decision-making of their government before the decisions are made.
Right.
So that right of participation, most people have experienced every time they get a notice of a hearing. It's because of that constitutional provision. Every time they're at a meeting and there's an agenda, and if it's not on the agenda, your county commission can't act on it, for example, or whatever board you're in front of. They have to be on the agenda so you know, and you have to have notice ahead of time. Those things every Montana has participated in, and most Montanans don't know that. None of that was there in the old Constitution. Correct. So let's talk about the right of participation a little bit.
Yeah, it's something I actually cared deeply about and was studying in graduate school. There was a lot of discussion about participatory democracy, and in general about the fact that government should not be in a position where it makes decisions and then people get to read about them in the newspaper. There had to be more opportunities. And people were thinking about it not just at the local level, state level, but also at the federal level. So it was something I did a fair bit of research on, and at least in my conception of it, it over time should become even broader. Obviously, key things are notice of meetings, agendas, meeting schedules so that people can effectively participate, enough time, and that they can offer their views. Even sometimes share a bit in the deliberations that occur. Not make the final decision, obviously, but also have their input responded to in an effective way, and I see a lot of that in documents now. So give folks access to the deliberations, not just the opportunity to be notified about the outcome that they had really nothing to do with. And the right of participation was unique enough that it generated a lot of discussion on and off the floor. It took a while for people to absorb it. There were efforts to strike the provision in its entirety. And
well, the way Montana government operated under the '89 Constitution for 83 years is fairly, could be said to be perhaps dictatorial at times. I mean, it was. Okay, we made a decision, we might tell you about it.
Yeah.
You know.
Well, people would prefer, when you're in a decision-making capacity, not to have a lot of help. Right?
Don't bother me, I got a decision to make.
And there's even an argument people make. Conversations among deciders are more candid if they're not in public. And you know, there's a point to be made there, but it has severe limits, and it was clearly overdone. So in general, I think the move to allow people to participate more was very important, and obviously it had to have a companion. Mm-hmm. If you're going to participate effectively, you need access to materials, to documents, and that's the right to know. And that was another one that
let's get into the right to know. We've talked about participation. Let's get into the right to know, and then we'll talk about privacy, and then we'll talk about the nexus of those, and how you guys resolve some problems. And then I'd like to make sure we have time to get into the dignity section.
Yes. We do have 3 days for this, don't we?
Yeah. So about the right to know.
Yes. Openness in government has been a tricky subject for a long time. And we had a lot of help from the media, and their observation was, if you're not careful here, you're going to create an empty right to know because you'll have an exception to it that will essentially wipe it out. And they'd had a lot of experience dealing with Montana's statutes, nothing constitutional, and they weren't particularly happy with that. But this would be one of the very first times that someone had elevated the right to know, open documents, access to files, and so on, at the constitutional level. And when you put it in the Constitution, you need to get it right because it's difficult to change. And importantly, these constitutional provisions are designed to be interpreted by the courts. Mm-hmm. They're not just left to the legislature, you know, to do whatever they can manage to put together.
Well, you do have it in the Constitution. You might say it's serious business.
It is. And that's how it played out. It was taken seriously. And we might as well link it to, if you're going to talk about the right to know, you have got to deal with privacy, one way or another. The two are going to meet up as soon as somebody pulls a folder out of a file, virtually any one. And so the question is, how do you balance those? And we worked on that very hard for a long period of time. I know Wade and Bob Campbell, Dorothy, I got others, and I spent hours and hours trying to sort through that. And early on, it was starting to look like we weren't going to make it. We were going to have a very unsatisfactory outcome. The press was very upset. As I say, they were worried that you're creating this right to know, but then there's this privacy thing that looks like it's just going to wipe it all out.
And you did have a strong privacy provision.
Yeah, that kind of was developed on its own. The meeting between the two of them was what we had to work on.
Right.
And what we said is, okay, you have the right to know unless the demand of individual privacy exceeds the merits of disclosure. And we were pushing ahead with that. Dan Foley, prominent journalist at the time, kind of liked that. And we talked some more, and finally I remember we had a small conversation, some of us, and we said, we've got to do something better with this. And we came up with the word clearly. I don't want to get too much into inside baseball here, but you had the right to know unless the demands of individual privacy clearly exceed the merits of disclosure. So we tilted the balance slightly in favor of the right to know. And we discussed that with the media. Some felt somewhat more reassured. Jerome Cate, a delegate who was not on the Bill of Rights Committee, continued to argue that the privacy provision would overwhelm right to know. Lengthy debates and discussions. It was adopted. And I think you've heard Chuck Johnson, a prominent reporter for decades, one of the great journalists in Montana history in my view, and others say, on balance, they're glad it's there. There are still some complications. Occasionally you run into long delays. Occasionally you get the agency telling you you're going to owe us a lot of money, to make these photocopies.
We have a little effort at erosion of these rights sometimes every day.
It's been constant.
Including right now over the issue of, hey, do you want to see our papers? It costs you $31,000, and guess what? A court said you can't do that.
Yeah.
That's the beauty of the checks and balances system and interpretation.
People try to recharacterize meetings so, this is just an informational meeting. It's not really a deliberation, and these documents are, all kinds of problems.
But you did have a really almost a crisis, didn't you, where the newspapers at the publisher level were saying, wait a minute now, we're not sure we like this thing, and knowing that you had to go out and make this past the people, having the newspapers against you would probably have been the death knell. You had a little bit of a summit. Tell us about that.
Well, front page news. We had an editorial on the front page and a number of other editorials that basically said, if this is in the document, we in the media will oppose it. And that's serious. I mean, everybody knew this was, we saw the experience in other states, and we knew that there were enough issues in here that were pretty fundamental changes that this could take it down. So there were actually a number of conversations. Informal for the most part, but very direct, and it started to become clearer, particularly with this one word I mentioned that I think matters a lot. It did matter a lot to people who were involved in it. We had strong support as well. Common Cause and others were very strong supporters of the provision. Bottom line, it went in, and there's a lot of case law on it now, and it's more and more a settled matter. And that's a good thing. This state is more open because of that than it ever was, and it's more open than many states. And I think people are rightly enthused with the access they have, both because of the right to know and the right of participation. The right of participation was actually qualified late in the debates on it. So you have the right of participation as provided by law. Now that's an unusual thing to put in the Bill of Rights, because ordinarily the right is there, and the legislature is supposed to be consistent with it. You don't declare a right and then say, the legislature will figure it out. I still think there's room for the judiciary, as on almost all the other provisions in the Bill of Rights, to play a role if what the legislature provides is just clearly inadequate, because people do have a right, and it may not be perfectly self-executing is the legal term, but I think under the right circumstances there may be opportunities to expand it. And I hope there is, because as I said, it was a little bigger issue for me than notice of meetings and that kind of thing. I think there's an opportunity to use more collaborative experiments to address some of the big issues, particularly local and state, bringing people together into sessions to try to work things out better than the typical public hearing and then later decision. And I hope there are more experiments like that. I wish there were more.
Well, when you had your final meeting with the press to kind of put this to bed, hopefully at the time.
Almost.
You met in the governor's reception room with the wood paneled walls, and they're all around the big table there. And I'm reminded of of Hamilton on stage, or the song about being in the room where it happened. It kind of happened right there.
It did. I was never sure it was over until it was over, though. We didn't have, there wasn't a standing ovation, okay? And it wasn't entirely kumbaya.
You were tiptoeing around it with him still.
I think it played out in many informal ways, and there were other provisions where the same thing happened. There was almost never a truly magic moment in the business.
But we do have a really strong right of privacy.
Yes.
That's important. Adheres unless there's virtually a clear or compelling state interest in that. So if they have a file on you and you're a Montanan, and there's some stuff in that file that is very private, and it's of no import to the decisions that are being looked at, that's going to be kept private.
Yeah, and
that's the theory.
It's a right of individual privacy.
Right.
Bob Campbell was very insistent about that. He didn't want corporations or other entities claiming that they had privacy. You can imagine an electric utility saying, "Well, these are our private internal deliberations, and And so our right of privacy is being infringed upon. It's a right of individual privacy. And that was something he clarified. He was very explicit about.
Well, it's good that it's there because, frankly, I've seen many a time where the corporate entities still claim it.
Sure. Well, they're and they do it with some enthusiasm.
Yeah.
Well, and it can't be infringed without the showing of a compelling state interest. That's a kind of a term of art, but it's a high bar to clear. And I've often wondered how we got in the position. I know with 9/11 at the federal level, there were some new, more intrusive regulations and practices to try to ferret out terrorist activities in advance. A bigger issue to me is in the private sector. Every time we go to our keyboards or use our cell phones, there's an enormous amount of information collected about us, where we are.
Not 50 years ago, but now, especially.
Now, and it's been exponentially increasing. There are these enormous databases on everybody. It's really where you were, what you did online, and now even operating systems are sifting through emails and documents.
They can go right down to picking up keywords sometimes.
That's exactly what they're doing.
Yeah.
Yes, and of course it's not supposed to be individually traceable and all that,
right.
But give us all a break. And what I find fascinating is that here in the U.S. there is almost nothing with any robustness to it to try to deal with that. You have to look to Europe for some real work, maybe California on the privacy side. So it is a right that is still very much at issue, even with provisions like the Montana one, which is very strong. There are major privacy questions, and you can even ask, how much privacy do we really have in these days? And I think there's a fair argument that it is severely diminished, and it needs some attention promptly. And you'll, in any case, you'll still have all that material that has been collected. And I'm not just talking about the big companies, but there are a lot of click companies that are associated with them.
There's been some writing and thinking about that. I know one particular person in Montana, retired Associate Justice James Nelson, has been doing a lot of writing and thinking and showing Montanans that actually, again, Montana's constitutional provisions give you more protection than if you're somewhere else.
That's right.
That doesn't mean we can't override we can't override the federal Constitution with our Constitution, but federal statute starts intruding too far. We have certain rights we can go into Montana courts on that protect us.
Yes.
Let's.
I hope it becomes a model, by the way, for broader application. I really do.
What about, we have an interesting section, a very important one, on individual dignity.
Yes.
We should talk about that while we have time.
Yeah, when I was doing my research, I found a provision like that in Puerto Rico, of all places. And I called it to the attention of the delegates. And that's one of those where I was frankly surprised that suddenly there was a fair bit of interest in declaring that the dignity of the individual is inviolable. Now, those terms are not commonly explored with a bunch of case law in the history of it.
That's a pretty remarkable statement at the beginning of that section.
It's new. In fact, it reminds me a bit of probably the early days of, we all know about you're entitled to due process of law. Well, back at some point, those were 4 words that didn't have a lot of meat on the bones. We're in a similar position in some respects with dignity, although a couple of profs, Tom Huff among them, wrote an article on dignity that I've cited quite a bit, and others, John Ellingson and others, are working to try to expand it. You can read it with some other provisions in the Bill of Rights, and it has an awful lot of meaning that we haven't really defined legally.
Not fully explored yet.
I'm looking forward to it, though.
Yeah.
It opens a whole range of issues that even go to cultural identity, for example, which was another interesting issue. You know, I was in the rotunda, and there was a discussion of the Native American education provisions. Well, 2 young Native Americans came before the Bill of Rights Committee during the convention, and they testified about the lack of relevant education and the importance of preserving their culture. Well, we stuck culture in our discrimination provision and went to the Education Public Lands Committee. Rick Shampoo was the chair and Bruce Severs was the researcher, and they took the education piece and put it in their provision. So there was a linkage between dignity, protecting culture from discrimination, and that education provision that took so many years to implement.
And in the dignity section we're talking about, there is an anti-discrimination section of it.
Yes.
Which, let me just, before we get into the meat of that, say that perhaps the uniqueness of it is it applies not just to state government, but to the private sector.
Well, and that goes to what we were actually trying to do in the Bill of Rights as a whole. Everybody knew that civil liberties are protections against government. And they also had an idea that civil liberties are protections against runaway majorities. Those are two common things from history back to the colonial days. But there was this third element, and a fourth actually, but the third one was to protect people against private sector denial of civil liberties. The fourth element was the one we kind of talked about with right to know and participation, is creating the foundation, a positive foundation for effective citizenship. People don't talk about that one enough, and I don't think they talk about the third one enough, and that's why we haven't developed
But
more
it is
provisions.
intriguing. We had just emerged, and we weren't even out of it, and we're still not out of it, frankly, the civil rights period in the 60s, in which it was very clear that discrimination was not exclusively the province of government, state or federal. It, in fact, was very heavily tilted toward private discrimination, which was sometimes allowed by government or permitted by ignoring it, but nonetheless, a lot of the discriminations were private. And in Montana, at least, there's the ability to try to apply that. But we learned some lessons in the civil rights of the 60s.
That was in the middle of our thinking. That was the genesis of this provision. And there was an effort actually on the floor to trim it back so it only applied to government discrimination. And that was defeated handily. People understood by that point, as you said, the private sector was fully capable of infringing on people's civil and political rights. And that still needs a lot more work in the country. We're not out of that. As a nation, we've had decades of history with those kinds of problems. As far as I know, this was just about the first to include the private sector. I think it was a huge step.
Why don't you read that section for us, the individual dignity?
I don't think I have the section. No, I don't have the precise
You don't have the Constitution
language.
with
No, I don't.
I should have brought the Constitution with me here.
I've got this article that boils it down, but no, I don't. But it was very clear that not just governmental entities, but individuals and private institutions.
And it did apply to culture and to social position. And
let me see. Yes, it by persons, firms, or institutions, any discrimination that would limit the exercise of civil or political rights, whether based on race, color, sex, culture, social origin or condition, or political or religious views. Now that's from my law review article, but that's the language of those categories. It's about as broad as you can conceive. We didn't, as far as we know, we didn't leave anything out. As if it affected your civil or political rights, whether based on any of those categories, it was prohibited.
And that's a discrimination.
Yes.
Which inherently, your dignity as a human being is offended by discrimination.
Well, and you can take, as I say, you can take those two and maybe even pair them with some others, and you start to get a clearer picture of the potential of the dignity language. There's also the guarantee of equal protection is in that same provision, but it's generally thought to be not fully rolled in. It stands on its own as well, and that's important. So that's one of the most important provisions. And it's very different from anything else out there, basically.
Let's talk a little bit about back to the process.
Yes.
You were meeting as a committee.
Right.
You had quite a group in your committee, pretty I mean, those are really wonderful people that were on that
They were,
committee.
and they grew to enjoy each other's company. They spent a lot of time together, which is interesting to see because by and large they didn't. A few of them knew each other, but ahead of time, but most did not. And the level of sort of formality, the feeling of a certain amount of social distance, dissipated fairly quickly. And part of that was the pace and the seriousness of the work, but it was also personalities. Wade, he was very assertive about things, very personable at the same time, and he managed to, with all of these
Corral all that
provisions,
stuff, didn't he? Yeah.
it was nearly unanimous on everything.
So when it came out to the floor, the procedure was you had a committee, you finally voted on it, you came up with the language, it went in for a little smoothing out by the Style and Drafting Committee, and it went to the floor.
Right. We had provisions. We had the source of them identified, which proposals were accepted, which were rejected, and then we had statements of committee intent for each provision. And I actually drafted those, and we were pretty close. There weren't too many amendments to those as we took them through committee to the floor.
Right. When it hit the floor, what happened?
Well, we were scheduled like everyone else, and when our turn came, we took them up one provision at a time. Typically, Wade had each delegate carrying one of them, reading the introductory statement, and then dealing with the debate. It depended on which committee member felt most comfortable answering whatever questions came up. Some of them went through very quickly. Some of them, as I mentioned, the right to know certainly did not. And the proposal survived basically intact. There was one particular addition that we shouldn't lose sight of. It's an important one. And it had to do with I said I'd researched the environmental issues and I was made available to the Natural Resources Committee, but it was their jurisdiction. So they worked their way through what they could accomplish in their article. And it was kind of unsatisfactory to the chair, Louise Cross. She wanted stronger provisions. And there was some communication between, I don't need to go into a lot of detail, but between Bill of Rights and the Natural Resources Committee. And when the Bill of Rights proposal was on the floor, Reverend Bill Burkhart, a Republican, and I actually did have to look this up recently, I've forgotten, he stood up on the floor, I mean, he and I talked some about this, but he stood up on the floor and said he thought it was important to add a right to a clean and healthful environment. You had an obligation.
Which had already been put into the natural resources,
there, but it was an obligation, and it was kind of unclear. And he said, we have the obligation, but we don't have the right. We've got a lot of rights here. Well, Wade DeHood stood up because he was worried about whether Delegate Burkhart was trying to expand the ability of anyone to sue just on general environmental considerations, and he was worried about the effect on the economy in his area. He made that very clear. So he asked Delegate Burkhart about that. Is that what is going on here? Because the convention had already rejected an amendment that broadly expanded standing cap. So he got his answer from Delegate Burkhart. It went in, and it has turned out to be a very key piece of the clean and healthful environment.
It means a lot that Montana actually has that right in its Bill of Rights, the clean, healthful environment. And as Wade now says, or now did say before he passed, after all, who wouldn't want a clean and healthful environment?
Exactly.
It's an when you really get down to it.
It's an inalienable right.
Yeah,
it's a fundamental right.
A fundamental right in the Constitution.
Yes.
Well, Rick, time's running out on us. It goes rapidly when we're talking about such fascinating information. You were in the room where it happened on this thing, and you helped craft the whole thing. And I want to, as a citizen of Montana, thank you for your involvement in this stuff, the difference it's made to Montanans for 50 years, and for hopefully decades and decades to come. And so again, thank you for this, and for bringing your knowledge and awareness of all this to us. And for all of you who are watching, this is Last Best Constitution. This has been a magnificent discussion of the very, very important Declaration of Rights that we have. And remember, folks, you're the most protected citizens in America. We'll look forward to seeing you on the next episode of Last Best Constitution.